Sorry, I think there is some technical issues. Vakritunde Mahakaya Samaprabha Nirvighnam Kuru Me Deva Sarvakaryeshu Sarvada Sarvakaryeshu Sarvada. The progress and the well-being of humanity rest on its capacity to create and invent new works in the areas of technology and culture. Intellectual property rights are the rights given to persons over the creations of their minds, inventions, literary and artistic works, symbols, names, and images used in commerce. The National Intellectual Property Rights, that is IPR Policy 2016, was adopted in May 2016 as a vision document to guide future developments of IPR in the countries. Legal protections of new creation encourages the commitment of additional resources for further innovations. Its clarion call is Creative India, Innovative India. Moving further, now I would like to call upon Dr. Rangaswamy D, Director of Equatus Victoria Research Center, Bihar, for the welcome address and introduction of.
Good evening to you all. Respected Chief Guest, Dr. Raghavendra sir, guest of the honor of the program, Ajay Sadasiv Thakur sir, all the principals of organizing institutions, principals, participants, students, ladies and gentlemen. I am so delighted to welcome guests of the today's valedictory program of two-day international webinar organized by Vaikunta Baliga College of Law, Udupi, in association with Dogra Law College, Jammu, Durgapur Law College, West Bengal, Anand Law College, Gujarat, Anand College of Legal Studies, Gujarat. After successful sessions of the various, after successful session of this today international webinar, we are here to formally conduct that valedictory program. So I am extremely happy to welcome and present chief guest as well as guest of honor of the valedictory program. So the chief guest of the program, so Dr. Raghavendra sir. So I personally feel like sir is the finest, fittest, and apt person for this program. So I would like to present sir to this August gathering. So sir, he holds several degrees and postgraduate degrees in his name. To name a few: MA in Development Studies, Public Policy and Management from Tata Institute of Legal Studies, Mumbai. MA Gold Medalist, MPhil from Osmania University, Hyderabad. JRF Scholar of UGC. LLB from Delhi University. LLM from GGSIP University, Delhi. Very recently, sir is awarded with a PhD degree from GGSIP University, New Delhi. So, so far as sir professional background is concerned, so sir is a retired civil servant from Central Secretariat. He worked as Joint Secretary, Department of Justice, Ministry of Law and Justice since 2017. He was also Mission Director for National Mission for Justice and Delivery and Legal Reforms. Sir took initiative for implementing policy reforms for improving enforcing contract parameters under the ease of doing business and e-contracts. So sir has taken vital role in this process. Earlier, he was Joint Secretary in the Department of Industrial Policy and Promotion, Ministry of Commerce and Industry, Government of India, New Delhi. Sir, here he has contributed to various free trade agreement, that is FTA negotiations and RECP agreement. So there he has also held additional charge of Director General National Productivity Council from December 2017 to May 2016. So he is former Registrar of Copyrights of Indian Copyright Office, where he has played a key role in the introduction of recent amendments to the Copyright Act in 2012 and Copyright Rules 2013. Sir has attended many WIPO NCR meetings and FTA negotiations as member of Indian delegation. He made significant contribution to recently concluded two WIPO treaties that is Beijing TT on audio visual performances 2012, and the Marrakesh Treaty to facilitate access to published work for persons who are blind, visually impaired, or otherwise print disabled 2013. He has contributed to the revision of copyright regulations of various nations such as Bhutan, Myanmar, Nepal as copyright expert. Sir has participated. So I used to follow sir in that social media. Minimum in a month, there would be 4 foreign trips for sir. So to such an extent, sir has traveled across the globe. So accordingly, sir is a resource person. He gives lecture talks on copyrights and related rights in various international and national seminars and workshops organized by different educational as well as professional association. So having this kind of personality for this seminar on intellectual property rights, really we are blessed to have sir with us for this valedictory program. Sir, on behalf of all the organizing institutions and on behalf of all the participants, students of all these institutions, I warmly welcome you to this valedictory program. Welcome you, sir. The guest of honor of the program, Dr. Ajay Sadashiv Thakur. So as the educational background of the sir is concerned, he obtained MSc from University of Pune in the year 1994, postgraduate diploma in business management from University of Pune in the year 1998, Master of Management Sciences from University of Pune 1999, MPhil degree from University of Pune in the year 2002, a PhD degree from University of Pune in the year 2011, LLB from Mumbai University. So he was the recipient of Dr. Babasaheb Ambedkar Sanitary Award for securing the highest marks at Mumbai University. Sir is also LLM holder. So sir has done post-graduation in LLM, that is Intellectual Property Rights and Information Technology from University of Mumbai in the year 2010. So he has obtained many certificate certificate courses. Sir has done many certificate courses. He also worked as, so far as professional background of the sir is concerned. So he has worked as senior scientific officer to Hindustan Antibiotic Limited Pune from 1995 to 2003. He has experience as a senior scientific officer. He has led many scientific teams relating to intellectual property issues. Having such kind of personality for this valedictory program, so that is very appropriate and suitable. Personally, I feel so. Sir, on behalf of all the organizing institutions and participants, I would like to welcome you to this valedictory program, sir.
Thank you.
Welcome you, sir.
Thank you.
I would like to welcome all the directives and principals of organizing institutions and paper presenters, participants, students, and each and everyone who are part of this valedictory program. So I welcome you all.
Thank you so much, sir. I would like to invite Dr. PSman, Assistant Professor, Vaikunta Baliga, Kodupi, for the presentations of the international seminar.
Hello. Am I audible?
Yeah, you are audible. Go on.
Good afternoon, everyone. I take it as my privilege to present before this esteemed gathering the report of this 2 days international seminar. The 2-day international seminar on the changing scenario of intellectual property right and the way forward got inaugurated on 21st July 2023 by Justice Nikhil S. Khariel, Judge, High Court of Gujarat, along with Professor Dr. K.C. Sunny, Senior Professor of Law, Central University of Kerala, as chief guest, and Professor Dr. N. Sambath, Dean Faculty of Law, University of Colombo, as the keynote addresser. Professor Raghunath K.S., Principal of Vaikunta Baliga College of Law, welcomed the guests and the participants joined both online and offline. Justice Nikhil S. Khariel, in his inaugural address, laid down the importance of IPR in the present era. He embarked that IPR is an intangible creation of humans. In the present times, where there is digital evolution, it is important to have IPR protection for societal progress. He also mentioned that IPR has made its impact upon the country's economy, and there is need to encourage startups relating to the same. And in order to boost IPR, it is important to understand the framework of the same. The chief guest of the inaugural session, Professor Dr. K.C. Sunny, pointed out the conflict that is arising between IPR and human rights. He also mentioned about life-saving medicines being controlled by patent, which would result in excessive pricing of the product. The keynote addresser, Professor Dr. S.N. Sampath, made a remarkable statement that IPR is gold and oil of 21st century, and it is an invisible gold in Asia, which cannot rise without robust mechanism. IPR forms like domain name, trade secret, traditional knowledge, which requires much more recognition for the economic benefit of the country. It is followed by a video presentation of each collaborated institutions about their institution and achievements, followed by the respective principal's message. It has given the audience an outlook about the concerned colleges. Professor Dr. Nirmala Kumari, Director of Legal Studies, Vaikunta Baliga College of Law, rendered presidential address. The inaugural session ended up with vote of thanks rendered by Professor Dr. Rankaswamy D, Director, Acuitas Victoria Research Center. Thereafter, the first technical session was addressed by Professor Dr. T. Ramakrishna, National Law School of India, University, Bangalore. He threw light upon the protection of industrial design in UK and India. He also explained the legal framework of Designs Act 2000 and gave special reference upon novelty and originality that should be present in the invention. He explained in brief a process of registration, rights of the proprietor's infringement, and its related cases that come under designs laws. The technical session began at 11:45 a.m. in two parallel divisions, which was chaired by Professor Dr. Prakash Kanive, Dr. Anish Pillai, and co-chaired by Dr. Santosh Prabhu and Dr. Duvari B.N. Pradeep, and sessions were coordinated by students of Vaikunta Baliga College of Law, Udupi. The second technical session was presided by Professor Enrico Bonadio, and in his address made a mention about intellectual property in connection with artificial intelligence. He embarked his view upon human-created AI, which in itself is capable of creating another invention. Hence, there is growing conflict with respect to human authorship in case of invention made by AI, which requires originality. The session was handled by faculties of Anand College and College of Legal Studies, Gujarat. The technical session was outstandingly handled, and it was excellent with the participation of various paper presenters in and around Gujarat. On the second day, 22nd July 2023, the third technical session was commenced, and it was handled by faculty members of Law College, Durgapur, West Bengal. It was taken over by the resource persons of the session, Dr. Amita Shenoy, on the topic Feminist Methodology and IPR. She highlighted major problems under IPR like funding, lack of recognition, less focus upon science, technology, and mathematics. She casted her view upon gender disparity, where men is being recognized more than women, and women are considered as object in advertising commercial creation. The fourth technical session was taken over by Professor Mohammad Mustafa Hussain, assistant professor from Bangladesh. He spoke about external and internal challenges faced in IPR. When it comes to external challenges, there is an obligation towards the international forum to set up standards relating to technology and financial transfer between various countries. Out of the 140 abstracts received for presentation, it was a hectic task for the organizing committee to make a scrutiny. Through this online and offline mode, almost 110 papers presented and about various aspects of IPR. The seminar ended up by remaining certain research questions for the researchers to explore in the coming future. So with this, I end up my seminar, my presentation. Thank you. Thank you so much. Over to you, madam. Hello.
Yeah,
I'd
Aruna.
like to invite Ravinder sir for secretary. Sir. Yes, sir. Am I audible?
Yes, you are audible.
Thank you, madam. I would like to invite the chief guest of today's event, Dr. G.R. Raghavendra, formal joint secretary, Department of Justice, of our audience.
Hare Srinivasa, Vande Matram. Good evening to all the dignitaries, and Dr. Amit Parmar, Dr. Rekha Singh, and congratulations to Dr. Jamol for giving excellent overview of yesterday's sessions, where apparently 140 presentations have been made. I'm just touched by the number of enthusiasts attended this great, international conference on the changing scenario of the intellectual property rights, and the way organized by four very important law schools: Vaikunta Baliga Law College, Udupi, Dogra Law College, Jammu, and Ananda Law College, the Gujarat, Ahmedabad, and Durga Law College, if I'm correct. So, very excellent day you must have had, noting down those suggestions and explanation given by the experts. Understand that the intellectual property rights, its interface with the human rights, technology, and the gender discourses, these are the main areas which were covered during yesterday's presentation. I remember when, as a senior officer, when I initiated the work of the national IPR policy in 2016 in the Department for Promotion of Industry and Internal Trade in Ministry of Commerce Industry. We knew that this policy has to be there, despite India has very robust IP laws, whether these are industrial property laws like Patent Act 1970, the Design Act, Trademark Act, Geographical Indication Act. And nowadays, you all aware that GI tag has become very famous, and the number of GI tag registrations are increasing by leaps and bounds. And Prime Minister Honorable Sri Narendra Modi ji has also given a call for one district and one product. Hopefully, the law colleges, whether it is Vaikunta Baliga, Udupi, or Dogra Law College, Jammu, or Ananda Law College, Gujarat, or the Durgapur Law College, West Bengal, are working in this direction, trying to find out which are the GI products available in their state or nearby states, how to make the producers of these GIs, geographical indications, or it is naturally occurring in this soil, grown in that soil, in that geographical area, are cultivated and produced by the growers there, maybe agriculturists, or floriculturists, or horticulturists, or the various manufacturers, whether the handicrafts or food items there, need to be identified, and their growers have to be registered, because unlike other intellectual properties, geographical indication is given to association of producers. Whether it's a patent, trademark, design, trade related rights, these are awarded, granted to the individuals. So basically, these are the persons. Persons means a natural person, it is the human. Unlike many people are creating trouble that why AI, a non-human, which is inventing innovation, or expressing autonomously and writing articles or books and creating a lot of artworks, etc. And no non-human is recognized. The very definition of person is either natural person or legalistic or juristic person. Coming to geographical indication, I was mentioned, this is the only legislation which awards the intellectual property rights not to the one person, but an association of persons which is registered. then they can claim for taking a geographical indication tag to the products either by produced by them or marketed by them or manufactured by them. So it now the burden is on all four law schools. If you have already ventured into doing this job, your surrounding district and in your state, please continue this. If you are not done, I advise you to start doing this. Start helping the people into these businesses. Make them aware of what exactly the protection of geographical indication law in 1999, which provides obligation by under the TRIPS agreement, which India became a member in 1995. So I request all the four law schools, if you have an IPR policy, it's well and good. But if you don't have an IPR policy, please have an IPR policy. What steps you need to do, the institution, one of the activities you are doing, conducting these kind of workshops and seminar, national level or international level. I congratulate you in doing this, but you need to have a policy which awareness, spread of IP knowledge, encouraging research. That's what you have done, organizing this kind of conference. That's good. This is only one thing you are doing under your policy. Other thing is the awareness among your academia. A law school may be an individual law school, or it may be a part of university where there may be an engineering school, which may be teaching the mechanical or electronic or computer science or data science, or there may be a pharma school, or there may be management school. So what you need to do, that the first initiative has to be taken by the law school, because it is the law which has to be made aware of to the people, the other academia, the scientific or non-scientific, the business schools or pharma schools. Everyone should know what exactly the patent is, trademark is, trade secret, copyright, geographical indication, design law. So it is burden on the law professors to teach these things to the other schools located in a campus, number one. Number two, because in the R&D laboratory college where innovation is happening, so they should not run and publish their research work, but they should register a patent first. So that is very, very important. These things need to be written clearly in your policy. So advisories to them and guidelines, etc., in detail, only the law professors can do this kind of job. Apart from making them understand that, what should be the who will own the copyright or the innovations created under the umbrella of your academic institution. If some patent is filed, so filing a patent has to be facilitated by the law school, because the engineer or the scientist who has done innovation and creativity of a new product or a process, he may not be knowing the legal processes of filing a patent application, how to draft a patent specification. All these things has to be taken care of by law school and the department who are responsible for that. I think there is a lot of cross talking. I request all of you mute your mics. Otherwise, I won't be able to speak. Or if I go on speaking also, others will not be able to understand and hear this. So I request you, please mute all of your mics. That's number one. Then the policy should state, not only help if, clearly mention where this patent or trademark or the Dr. Arunaji Jani, I think your mic is
sorry,
on.
Sir, that Sumiksha, we communicated, sir.
Yeah.
Sorry, sir.
And the IP policy of a university clearly mention what is the role
Diksha,
What is the role of each
please
department?
unmute
And
your
instead
mic.
instead of working in the silos, because when I was invited physically, I was speaking in online mode now. I don't want to give the names of those universities where only law school professors are there, or only the engineering department people are there. This should not happen. Actually the creativity innovation happens in the R&D labs of the scientific and engineering department, and they need to take the legal help of the filing and the right drafting patent specification, or tomorrow you need to have a trademark filing that is from them, or design innovation is happening, the design application, all these things only the law guys can help. And tomorrow simply filing a patent and with the help of law professors is not suffice. So even though it passes the test of the novelty, these things, the prior art search, what exactly the prior art search, how this need to be done, a kind of training has to be given by the last to the faculty in collaboration and coordination with these departments, whether it is a scientific or engineering department doing design work or innovation work and all that. And when the law and engineering scientific are together or done, the next step will be the commercializing, whether there's a technology transfer happening. Again, the law department will go through those kind of agreements and drafts. But the actual commercialization, the technical aspect, the business aspect have to be seen by the management department, the management school in your university. No, they should not be out of this process. So they are the experts in this. So what I suggest is your universities or institution policy should mention all these things. Well, who are the people going to do these role plays? Which are the department going to contribute in these things? Then it won't stop there. You can have action plan written, how you work, and annually what kind of work you'll be doing, timely targets are given and all that. Then now the new technologies are coming, disruptive technologies are coming. It all started with the algorithms, the artificial intelligence algorithms, text data mining, natural process, language processing, NLPs, and then machine learning. The machine learning algorithm, it creates a lot of models. People try to jump and try to make statements that it's a gray area. Who will be the inventor? Who will be the author? Who will be the owner? Obviously, machine is a non-human. A non-human can't give you directions, even though it may be thinking autonomously, it may be working autonomously, and it may be inventing like Dabu's AI, which has invented food processing devices with the prompts given by this Stephen Thaler. Stephen Thaler tried to address this issue, try to prove that the innovator is the machine, not him. But all the patent offices clearly in one voice they have said that a natural person, human will be the inventor, can't be a machine. That is the decision. Similarly, the authorship, again the natural person, how machine writes a document or a project report. You have to give a prompting. Prompt engineering has become a new subject nowadays. What kind of prompt, whether it is a word prompt or text prompt, you call it, or a voice prompt to be given to these generative AI or artificial intelligence machine, how it is going to create. And another question is, of course, again, the law have said that only the natural person is the author, even though autonomously it's doing, but it is not thinking, all by itself. It has not created what is going in the brain of Dr. Ajay Thakur or Rangaswamy. Even machine doesn't know unless and until you give a prompt to it. It won't come the morning. It won't. The moment Dr. Rangaswamy wakes up, Dr. Rekha wakes up, it is Hi, good morning. Oh, you need a 5,000 word article on this. I'm going to write and give it to you within seconds. It won't say like this. You have to go and give a very good prompt, then only it will create and give it. And what is the problem? While creating this work for you, it goes into the legally available, digitized, copyright protected subject matter over the internet. And some may be available in various websites, even though these websites made this legal material freely available, but they have not foregone the copyright in this. When artificial intelligence collecting the information and creating a commercially viable output, then permissions have to be taken. Consent and compensation has to be given. Sometimes the encrypted device are put unless and until you subscribe. Many journals, you're all academic people, you know that none of the journal freely allows a download or a sharing your own article. Because you already given your copyrights to that journal, because you want to see your baby to be published, you want to proudly see how many citations have been given to your journal, your article published in that journal. But unless and until you put your password and login and password, you won't see your own article there on the online. Then how can you download and give it to other people? But if artificial intelligence machine hacking these things and collecting the data with whatever the learning model it is creating, and classifying the data and categorizing the data, whether the systematic data with the labeled data, that's what is systematic data, unsystematic data, unlabeled data. The entire machine learning process, the supervised learning happens in the when data is systematically labeled. Unsystematic, unsupervised learning model is created when data is not labeled, that is unsystematic data is made available. And these kind of learning models are created for the legally available copyrighted subject matter. People upload illegally a lot of databases and content. So AI machine collects that data following these learning models. And then there is, of course, there is a public domain material. You need not give any cite, but citation has to be given. You need not be taking up consent or giving any compensation. But what is happening? Those who have tested these chat GPTs or generative AI, even 100-word paragraph it writes, it collects the data and puts, even though autonomously the expression is the machine expression, it is a false expression because it is a pirated expression. No citation is given, no referencing is. As an academic person, seriously respecting the integrity, respecting the copyright and creativity of other academicians, how can you take away even a small phrase without a citation and reference? That is illegal and unethical. So this is what is being done with the help of this technology. And a burden is on you, my dear professors, to teach your students. Okay, if you want to use ChatGPT or GI, use it. But when final product comes, struggle to give the citation. Otherwise, that kind of submission should not be accepted. Burden is on you to make them aware of these things. That's why I said that there should be IP policy for each institution. It should mention all these things. And again, when the creativity happens, many professors said, "Sir, I have worked in the lab. I have created. I should file patent and patent should go to me." I said, "Who told you to do this? Your university told you to do this research project. They are giving you salary, and finally the patent will go to the institution, not to you. But there should be a model of sharing model, since your intellectual energy has been put in that in innovation, your creativity. University should develop a model of 60-40 or 50-50, whatever. but you can't take away because you're already getting a salary for that or some honorarium for doing that. So when it is commercialized, it is a university which is going to commercialize. Technology transfer, it is the institution or the university which is going to transfer that technology. We can't run away with that invention and claim that that is yours. So university should have a policy to give encouragement that, that intellectual, that beautiful mind, the professor with that beautiful mind who can create such things should be encouraged. Normal salary honorarium will not do. Some when technologies transfer, some profits are earned by the institution. What should be the sharing pattern so that the more young minds can be drawn to indulge themselves in the creativity. So these need to be clearly mentioned. Also, when new things are happening, the international law is also changing. When the WIPO or the norm setting happens, there is a standing committee for the patent and design, standing committee for the trademark, standing committee for the copyright and related rights. Two important laws are coming. I know there's so many people are attending this international conference. The two new treaties are coming. One is the new design law treaty. Why there is a design law treaty? The TRIPS agreement already covers the minimum standards. 193 member countries of WIPO or WTO have implemented this in their national legislation. Why there is a need for a new design law treaty? This new design law treaty basically addressing the new rules of procedures of registration of a design. Of course, there are already many technological disruptions have come. The 3D printing has come, and then the artificial intelligence and many designs have been created which can be applied on the article, and 3D printing, it's creating again a new, it may be creating new designs or copying the existing designs. And if you say, if you look into our own design law, it is the most weakest of all the intellectual property laws which India has. Our design law doesn't protect it doesn't give any criminal remedies when design infringement happen. It has only civil remedies, and it is the only law which gives statutory damages. The concept of statutory damages we don't have under the patent law, or a copyright law, or a trademark law. Only design laws. Advance it says that 25,000 fine can be imposed. This kind of this thing. 25,000 is simply peanuts. And that guy is doing 24 crore damage to your design. So that need to be strengthened. Criminal remedies. There are no criminal remedies, just like US and EU countries and UK have. That we don't have. And also we don't have simple passing of remedy, similar to trademark as a passing of remedy. And the many design regimes, the stronger design regimes like US, EU, UK, Japan, other countries have. These we don't have. So we not only the design law treaty, which may be suggesting new procedures and laying down the new rules for registration, design registration. But these things also need to be addressed. And then coming to the patent law, and recently Delhi High Court has given two best decisions. This is in complete favorable to the very motto we adopted under the National Intellectual Property Policy 2016. What is the motto? Creative India, Innovate India. So while protecting the rights of creators, the law should provide creativity, also promote the innovation. And that's what the Delhi High Court says in one of the cases. Faridi Alani case clearly says that, the computer-related inventions guidelines of the patent office, the new guidelines are not favorable for promoting the innovation in India, whereas the old guidelines are far better. So they need to be re-looked into that. So because 3 case terms, the the patentability of software is the computer program per se not patentable, or algorithm not patentable. Business method and not because they're not inventions. These are all abstract ideas. Unless and until similarly the CLS bank case, Allies versus CLS bank case of the Supreme Court US clearly says these are all these software, computer programs, algorithms are abstract ideas. And until these perform a technical function, like iOS makes your iPhone to function, Android software makes your Android phone to function. So like that, these need to make your things to function, then a patentability will come. But in this system, it should not be any strict guidelines, should be innovative, promoting innovation, creativity. That was it. It says, even the recent Delhi High Court judgment also come on the business method patent. The advice has been given by my friend Justice Pratibha Singh that government should have a look into how the business method patents are patentability of those things. So in this disruptive innovative world we are in, where everything will be ruled by artificial intelligence machine, but don't become a slave to artificial intelligence machine. Ad nauseum, I keep saying it's only a general purpose assisting tool or a technology which it makes your life better, whether inventing or researching or doing a surgery or whatever work, intellectual work you are doing. You should not take over and start ruling us, you or me or us. So again, congratulate all the 4 law schools, including Dr. Rangaswamy and Dr. Rekha, others who have taken initiative, Dr. Amit Parmar, others, and wish you all the best. Jai Hind. Thank you for inviting me to share my thoughts in this valedictory function. Thank you.
Thank you, sir. Thank you so much, sir. Thank you so much.
Thank you so much, sir. Before going ahead, I would like to request again to all the participants, please mute your mic so the session can be continued smoothly. I would like to invite the guest of honor of today's event, Dr. Ajay Thakur, sir, Deputy Controller of Patents and Design, Indian Patent Office, Mumbai, to share his valuable knowledge to our audience. Sir, your mic is muted.
Good evening, everybody. Hope I'm audible and visible also.
Yes, sir. You are audible, visible.
Okay. First of all, let me thank Dr. Ravinder sir for enlightening us with this deep knowledge regarding these different intellectual properties which I have shared. And also, I am aware that a lot of things might have been discussed yesterday in your sessions relating to different IPRs and the changing scenario wherein different issues might have been discussed. I would like to first of all add that sir has rightly pointed out that there is a need of intellectual property policy, which every university or college needs to be having it. There are certain issues which we have faced personally while dealing with some patent applications, wherein the applicant and the inventor face certain issues with regard to patentability right issues. As such, there was one case wherein I was a controller, and wherein the student who has done PhD under IIT has then refused to give the rights to IIT, wherein it was not clear that the IIT was having a IP policy. So sir rightly pointed out, and we have to refuse that application. Neither IIT got the benefit, neither the applicant, the inventor got the benefit. So what sir has pointed out is very correct, that IP policy needs to be in place, wherein all the clauses should be clearly defined, stating that who will have the ownership, or what stake they will have, whether there will be revenue sharing, what sort of revenue sharing will be done, whether there is 50-40 or what sort of proportions. Because ultimately the research organization spends a lot of money on this thing, on the research which has been carried out with the help of the inventors. So Yes, I do agree with sir's opinion that there should be certain intellectual property policy, and which should be clearly defined, stating all the clauses very clearly that the intellectual property created during the tenure of this work will be the property of the organization, or there is maybe any subsidiary clause like some revenue sharing will be there, or some sort of benefit will be shared with the inventors also. Now, coming to other certain issues relating to, sir has rightly and aptly pointed out about the geographical indications, and raised certain issues about copyright, then again design laws, and then relating to copyright, further relating to patents also. So I, being an official of patent office, and I would certainly like to point out that certain revolutionary changes have taken place in the patent offices, in the working style of patent offices in India. When we joined this organization in 2003, we were like laymen. Now, since with the development and with the policies, IPR policies in place, we have certainly can say that we are again going ahead with the other nations also. As far as certain improvements which have taken place in the patent law, is that amendments have taken place in the patent laws. Time period has been substantially reduced. Then certain modernization of patent offices have taken place. Then manpower augmentation, certain to in to remove the backlog and to address the speedy disposal of patent applications, many examiners have been recruited. So IP manpower has been increased. Then modernization of IP offices has taken place to provide timely services to the applicants. Then further, we can say that we have started working as a paperless office, electronic processing. We are not, we are taking highly, earlier we used to take applications personally also, but now e-filing has been promoted. So you can file your application without moving from any place of the country. Then of course, this has increased. 90% patent have been filing has been increased, and almost 75% design application has been increased. Further, 10% rebate is also given on filing on these fees. So then we have stopped totally. We have stopped making the files. We are totally paperless office. Certain communication which we were sending through telephone, we were sending to post offices has been stopped. We have started working with email, and email services are being now provided to the applicant, and the applicant can give their email address, and the correspondence is directly sent on their email addresses. Then online delivery of patent certificates, then online delivery of registration of letter patents, and is also done through online instead of sending it through the postal correspondences. Then again, timely registration of patent agents exams has been conducted, and registration of patent agents also is being done on electronically. Then periodic publications of the first examination reports, which are also being was an issue, was also being addressed by periodic publication of FARs which are being issued. So there are a lot of things. Further, instead of coming to patent office for attending a hearing, we have started with the video conferencing. So all hearings are now presented through video conferencing. Then we have a dynamic website and information reservation services, where all the information is being clearly and aptly disclosed on our website. Then expedited application, expedited examinations, startups for applicants, ISA, IPR for patent applications have also been started. So certainly there are certain things which are being done in the revolution of patent offices. And then as far as creativity is concerned, as far as innovations are concerned, lot of awareness programs are being conducted through CPAM. And then again, we are as a part of Azadi Ka Amrit Mahotsav, we have started NIPAM, that is National Intellectual Property Awareness Mission, wherein we have trained almost patent offices have taken the initiative to train almost 10,000, 1 lakh, sorry, 10 lakh students or professors or college students or to about what are the IPR, different types of IPR, how these IPRs are governed, what different policies are there. So we have made substantial efforts in the patent cell to make aware about the intellectual property rights. Then we have again started with India. India has also become as a intellectual property search organization, ISA and IPA, wherein foreign PCT applications, Indian applicants can choose India as a searching authority, and these applications can be prosecuted there also. So as far as trademarks are concerned, manpower augmentation and business process reengineering has been taken place. Certainly, the output of trademark registry has increased. Then electronic communication also has been initiated in the design section for quicker processing of design applications. Then, as Sir said, many of the globally famous products, which are India's rich cultural heritage, have been registered under geographical indications. The Copyright also Act is also brought under the uh, control of Office of CGPDTM. So there are revolutionary changes which has taken place, and these are not only favorable for the organizations, but now certainly we have reached to many colleges, universities, wherein how to make, where to make, all these things are being clearly explained, and all these things are being discussed in detail with these colleges or universities. Certain college professors, then SIPAM, then all other NIPAM activities are also being allotted to college professors who are also conducting. Timely patent agent exams are being conducted so that the students or the participants who want to become a patent agent or who want to pursue their career in the patents can become a patent agent, and certainly they can give this output to them. So all these things have led to a very dynamic working of intellectual property organizations. And certainly a favorable climate has been created for the promotion or the filing of patent application as well as other intellectual properties also. So all these things are in favor of the patent offices where we can certainly make certain developments. As far as other issues are concerned, I suppose that are properly and promptly addressed by Sir. So there is one another issue which is being handled, that is feedback mechanism, wherein you can easily make a lodge of feedback examination or feedback suggestion, or you can make your complaints for filing a patent application, or what is the status of your application, what are the issue related with the applications, and these grievances, what grievances you are having are substantially and immediately handled and taken care of. And in the phase of that, when we had backlog of filings of backlog of many patent applications pending at our end. But with these developments, with the recruitment of new examiners and with the promotions of controllers, certainly the backlog has been reduced. So yes, there is a favorable part on that also, on that aspect also, wherein all these things are in favor of the applicants or the inventors or budding creators of the intellectual property. So I would like to sum up that yes, today in today's globalized economy, the role of IPR cannot be ignored, and it is an inevitable tool. So and all these colleges and particularly the participating law colleges need to act and adopt a proper policy or maintain a certain guidelines so that these intellectual property rights are aptly created and protected from your organization, and generally they will lead to the development of the college as well as the development of a nation. uh, I would not like to take much more of your time, because certain issues which were I was supposed I would have discussed, but sir has aptly and brought it to the notice about AI intelligence and all these things. So that need not be taken again and again. So as far as all these things are concerned, certainly yes, the patent offices and the intellectual property offices have developed and have taken a lead ahead of the what we were having about last 10 years when we just started our career there. Now we can proudly say that we are ahead of time, and certain reforms, revolutionary changes, amendments, certain working style, everything has been changed, and now we can even started working from home. So all these things lead to the favorable protection of intellectual property, as far as sir has pointed out, that that is a policy decision, and decision makers will take the policy about the criminal aspect and the civil aspect of the laws which are present. As far as we as working as a in the patent officials, we need to only take care of certain issues. I would like to point out that as far as when the idea comes to your mind, you should not keep it on in your mind, or you should not disclose it with somebody else, but you should write it on a paper, come for a filing of patent application, file a provisional specification, then you can file a complete specification. But please don't go ahead with the releasing of your paper, because earlier the concept was publish or perish. But now the concept is before publishing, you make an application for patent and then publish it. So now we come across many inventor, many scientists, or many researchers, academicians, professors, who say that they have done something and they have published it, but now they want to get a patent. At that time, we are also helpless. We cannot help them out, because already the application or the research paper is in public domain, and these people have already lost their novelty, and then it becomes very difficult to help them out. But here certainly care should be taken that before doing any other activity, you should focus on all the intellectual properties, whichever aspect you have, maybe a copyright, trademark, or maybe a design work, or maybe a patent work. You should be having awareness about that, whether this property will have some commercial value or not, and then only you go in for publication, or otherwise you make an application and then don't lose the royalty or novelty or inventive step of your application. So that is what I would like to explain or point out, that certain emerging career as a patent agents can be done. You can qualify those persons who are working as advocates, or those who are science graduates or technology graduates. Along with advocacy, they can become patent agents, or they can become patent agents and prosecute the application with patent offices. Also, as regard to the commercial side or art side, commerce side, these people can practice trademark, copyright, industrial design. So these are the things which can be done from these heads. As far as all other aspects are concerned, I suppose this seminar was taken care of all these things, as I was told earlier that all the guests or eminent faculties have delivered their lectures and have explained their properties, or explained their role in different intellectual properties. So I would not focus more on that, but I would certainly ask you to frame a proper IP policy wherein certain things will make it very clear. And apart from that, you take care of that, you make ensure that you create a proper organization or proper environment for filing this type intellectual properties in your colleges, so that the students or the budding inventors can be helped, or they can flourish in future also. So that's what I wanted to say from my side. Thank you very much.
Unmute yourself, Aruna. Aruna, you are not audible.
अरुणा बहन, आपकी आवाज नहीं आ रही।
Am I audible, sir, now?
Yeah, now you are audible. Now you are audible.
Am I audible? About listening, observing actively, taking the time to analyze, and then thinking of the best possible solutions to perform better. So here, if anybody wants to give feedback, then you are most welcome. By switching on camera and unmuting your mic, you can give feedback regarding this 2 days international seminar. Participants, if you want to give feedback, you are most welcome.
So Arun, nobody is there. Go ahead.
Okay, sir. Okay, sir. We have received many video feedback from the participants. So I would like to request a couple to play the videos.
So that the sound is not audible.
Am I audible? Thank you so much, Kapil sir. Now, I would like to invite Dr. Amit Kumar Parmar, sir, Principal of Anand Law College, Anand, for presidential speech.
May I request Dr. Amit Parmar sir for presidential remark?
Yes, I am audible, ma'am.
Yes, sir, you are very much audible.
I, Dr. Amit Parmar, Principal of Anand Law College, State of Gujarat. Today's international seminars, chief guest of the validity function, Dr. G.R. Raghavendra sir, former Joint Secretary, Department of Justice, Government of India. Guest of honor, Dr. Ajay Thakur sir, Deputy Controller of the Patent Designs, Indian Patent Office, Mumbai. Dr. Rajaswamy sir, Director, Equitas, Victoria's Research Center, Bihar. Dr. Jaimol P.S. ma'am, Assistant Professor of BBCL, Udupi. Dr. Rekha Kumari Singh, Dean of Sardar Patel University and in-charge Principal of Anand College of Legal Studies, State of Gujarat. All the coordinators, research scholars, faculty members, and all the participants from across the country. Namaskar. A very good afternoon to all of you. It is a privilege for me to address the valedictory functions of the international seminar on the changing scenario of intellectual property rights and the way forward, jointly organized by all the 5 institutions. I congratulate the organizing institution from South India, Vaikunta Baliga College of Law, Udupi, for this initiative and collaborating with other organizing institutions. I would like to appreciate the insights shared by Dr. G.R. Raghavendra sir as well as Dr. Ajay Thakur sir. I am sure that insights shared by the eminent guest will be very helpful for all the participants. From the global perspective, we as nation need to move forward at a greater pace in the era of intellectual property rights. Traditionally, our ancestors believed in open access to knowledge for everyone. They might have never opted for intellectual property rights in their times, so that we can access the knowledge with easy. However, in today's modern era and globalized world, especially from the business perspective, intellectual property rights and its best utilization in value creation is highly essential without any doubt. According to Bill Gates, intellectual property has the shelf life of banana. In the era of artificial intelligence, this initiative in a forms of conference can help us to understand today's changing scenario and the shelf life of intellectual properties in far better way. As a nation, we can reach new heights by understanding optimal use of intellectual property rights for strengthen our economy. I appreciate the efforts of all the organizing institutions and coordinators for their tireless efforts to put everything together. I would like to express my gratitude towards all the resource persons who have contributed as a guest speaker, chairperson, or coach, have contributed as a sir advice background and their valuable contribution. Thanks a lot of Jai Hind,